today's video, I'm going to share 5 common tricks that employers use to avoid being sued. As I stated in the previous video, burden is normally on the employee to prove unfair termination or wrongful dismissal. The employer only comes in to justify. Most employers find that fact that burden is on you, so they normally they put in some tricks to ensure that they are not sued in case of unfair termination. And you find not all, of course, not all companies, but most of these companies, you find they know that they are breaking the law, but now, and they know that you have a right to sue them, so they find ways of doing it. So the first common trick is ensure they avoid employment contracts. They avoid it. That's you even find. I know there are people who, when you have been employed even for more than 5 years in a company, but you don't have any written contract. This is a way for them to prevent any evidence to show that there's an employment contract between you and them. So that's one of the common things. Under the law, yeah, the employer is not mandated to draft the contract and now ensure there's a contract in place. But there's no law that punishes them for not doing it. That's why they use it as a trick. And then the other common thing is they pay you your salary in cash. Remember, when your employer pays your salary in cash, there's no paper trail, there's no evidence. So this is now another trick they like using. That's why we normally advise employees, make sure, just, there's some things it's up with, like, it's beyond your control. You can't force your employer to pay you through your bank account, but now you can just be you take the initiative of when you receive this, just write a message, a WhatsApp or an email, just telling your employer, I confirm receipt of my salary. Make it a habit. Now you see, for this, it's, at least, unless they repute it, now you see, at least for you, you'll be having evidence to show that this person has been paying you salary. So there's the only relationship now that can be between you, it's employer-employee. Another thing is they avoid any form of written communication. I know there are employees who are in companies where the employer will avoid any form of written communication. They prefer face-to-face meetings or just phone conversation. They don't put it into writing, they avoid it. So that's why that's why when you end up you find clients who don't have any sort of evidence for anything. Even some they come and they were terminated by word of mouth. Like, your employer just terminated you, like they tell you don't come tomorrow, by word of mouth in the office. Now see, there's no evidence when the termination has taken place. The employer can easily even backtrack it when they notice that you're even taking legal action. How will you prove that? It becomes hard. It becomes an issue of she said, he said, hearsay. So, and remember, under the Evidence Act, the person who is claiming something is the one who should prove it. You can't now make the other person, like now, for instance, that you can't say that my employer said I'm terminated, told me, and then now you want now the employer is not supposed to prove it. No. For them, they can deny it. There's no written evidence. So that's another thing. So another thing, they avoid payments like payee, because payee, they're doing payee payments for you as an employee. There's P9 forms that you can get from KRA. If they are paying NHIF and NSSF, you can access those documents easily, so you can confirm there is an employment relationship. So there are employees who completely do not do payee, they do not pay for you NHIF, they don't pay for you NSSF. So you see, now it becomes hard, like, for you to prove any form of relationship. Remember, for you even to claim unfair termination, you have to prove the other person was your employer. Before you claim any damages, you have to prove the other person. That's the first thing you prove. And as I've said, most employers will deny, even with evidence, the employers will deny. Now you can imagine how far they can go when there's no any sort of evidence. So these are the common tricks that they use that you should watch out. And then now the most common one, they make employees sign waivers that you're not going to sue them. This is now, after now they have terminated you. Remember, I normally tell people, these people, they are trying to protect themselves. They know, most employers will know we have not followed the law. So they know in case now after the termination, chances are you may go and seek legal action. So there are some who will make you sign a document. First, they use it as a trap. Maybe they want to pay you for your accrued leave days. So then they do some few payments here and there as a trap. They tell you, we'll give you, on condition of us giving you this terminal dues. Remember, you are entitled to your terminal dues. But they use it as a trap. And remember, now you're losing your job. So most people, which is understandable, they will take and sign. but avoid that's a trick. And remember, contracts are binding, just like an employment contract. They are binding as long as, of course. So the moment you have now signed a contract waiver, now that means you are signing, you are subjecting yourself, stating that I'm not going to. And the contract, these arguments will state that for you confirm that the termination was fair, and you're not going to be suing the company or seeking any damages. So be very careful. Be very careful when it comes to these tricks, and ensure you protect yourself. So I hope this video has been helpful. So I'll continue. The month of May, as I stated, is for sharing employee tips and rights. So I hope for the next video.